अस्सलाम वालेकुम या रसूलुल्लाह वस्सलाम अलैकुम या हबीबल्लाह। प्यारे व्यूवर्स, आप कैसे हैं? सब खैरियत से हैं? अल्लाह ताला आप सब लोगों को सेहत के साथ लंबी ज़िंदगी अता फरमाए। मेरी तमाम दोस्तों से रिक्वेस्ट है कि मेरे इस चैनल को सब्सक्राइब कर लें और घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुंच सके। प्यारे व्यूवर्स, आज हम पढ़ेंगे इमूवेबल प्रॉपर्टी के बारे में। डिस्प्यूट्स एज टू इमूवेबल प्रॉपर्टी, सेक्शन 145। Produce where disputes concerning land, etc., is likely to cause breach of peace. First, whenever a magistrate of the first class is satisfied from a police report or other information and that a dispute likely to cause breach of the peace, exhaust concerning any land or water or the boundaries thereof within the local limits of his jurisdiction, he shall make an order in writing stating the grounds of his being so satisfied that requiring the parties concerned in such disputes to attend his court in person or by pleader within a time to be fixed by such magistrate as in and to put in written statement of their respective claims as respects the fact actual possession of the subject of disputes. Number 2, for the purposes of this section, the expression land or water includes building, markets, fisheries, crops, or other produce of land and the rents or profit of any such property. Number 3, a copy of the order shall be served in manner provided by this code for the service of summons upon such person or persons as the magistrates may direct, and at least one copy shall be published by being affixed to some conspicuous place of or near the subject of disputes. Number 4, inquiry as to possession. The magistrate shall then, without reference to the merits or the claims of any such parties to right to possesses the subject of dispute, pursue the statements as so put in. Here the parties receive all such evidence as may be produced by them, respectively considered the effect of such evidence, take such further, respectively considered the effect of such evidence, take such further evidence, if any, as he thinks necessary and if possible, decide whether any and which of the parties was at the date of the order before mentioned and in such possession of the said subject, provided that if it appears to the magistrates that any party has within 2 months next before the date of such order been forcibly and wrongfully dispossessed, he may treat the party so dispossessed as if he had been in possession at such date, provided also if the magistrate considers the case one of emergency, he may at any time attach the subject of disputes pending his decision under this section. Number fifth, nothing in this section shall preclude any party so required to attend or any other person interested from showing that no such dispute as aforesaid exhaust or has existed, and in such case the magistrate shall cancel his said order, and all further proceedings thereon shall be stayed by but subject to such cancellation the order of the magistrate under subsection 1 shall be final. Number 6, party in possession to retain possession until legally evicted. If the magistrate decides that one of the parties was or should under the first proviso to subsection 4 be treated as being in such possession of the said subject, he shall issue an order declaring such party to be entitled to possession thereof until evicted therefrom in due course of law, and forbidding all disturbance of such possession until such eviction uh, and when he proceeds under the first proviso to subject 4 section 4 to subsection 4 may restore to possession the party forcibly and wrongfully dispossessed. Number 7, when any party to any such proceedings dies, the magistrates may cause the legal representative of the deceased party to be made a question arises to who the legal representative of deceased party for the purpose of such proceeding is all persons claiming to the representative of the deceased party shall be made parties thereto. Number 8, if the magistrate is of opinion that any crop or other produce of the property he the subject of dispute in a proceeding under this section pending before him is subject to speedy and natural decay, he may make an order for the proper custody or sale of such property, and upon the completion of the inquiry shall make such order for the disposal of such property or the sale proceeds thereof as he think fit. Number 9, the magistrates may, if he thinks fit at any stage of the proceedings under this section, on the application of either party shall issue a summons to any witness directing him to attend or to produce any documents or thing. Number 10th, nothing in this section shall be deemed to be a derogation of the powers of the magistrates to proceed under section 107. कमेंट्री इंशाल्लाह हम कल पढ़ेंगे, तो आज के लिए बस इतना ही। आखिर में मैं अपने तमाम दोस्तों को से गुजारिश करना चाहता हूँ कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके, और ताकि आप भी कानून से मुतल्लिक आगाही हासिल कर सकें।